Moderating the panel today is a journalist warmly familiar with the way the defamation laws operate, or most importantly, don't operate in Australia. Michael Batchelor, the investigations editor of The Age, will be leading an all-star panel. I'll briefly introduce them now, and Michael can run through in greater details who they are. Andrew Rule, as many of you know, is one of this city's leading journalists, also a man very familiar with the way defamation laws operate in this town. He is the associate editor of the Herald Sun. Gina Schoff, QC, great to see you. Gina, who has straddled both sides of the fence in defamation, representing media groups and also aggrieved plaintiffs. Great to see you here. Matt Collins, QC, everybody in the room here knows Matt. He has done some fantastic work on defamation, representing The Age and the Herald Sun, who describes the current defamation laws as a bit of a Frankenstein's monster of complexities and regulations, something I'm sure he'll elaborate on in his remarks to Michael. And finally, Tim Wilson, MP for the Melbourne seat of Goldstein, previously a commissioner at the Human Rights Commission. Tim also agrees defamation laws are a bit too strict, and therefore that means you can say or write anything you like about Tim Wilson. So it's a bit of a red rag to a bull there, Tim.
I'm going to start just by letting each person speak for a few minutes, starting with me, about our experiences of defamation law. Unlike Michael, I have been sued twice. One of them still ongoing, and it's an unpleasant experience. Most recently I got a threat from a law firm complaining about a story that I had written about their client that I wrote in June 2008. Now, under Australia's defamation law, there is a 1-year limit for how much you can, for how long you can take to sue. But the High Court, in its wisdom, has decided that every time the article is downloaded from the internet, that's a fresh publication. So they make it explicit that that's the basis on which they are suing me under this, for this 9-year-old article. And they refer to that case in the High Court, and then they add for good measure that this publication is incapable of being defended by you, which 9 years down the track may well be possible because witnesses may. David Poulton's advising me not to continue with that sentence, but this I think exposes something that is clearly wrong with our defamation law, and that is that a 1-year limit no longer applies to how soon you can sue somebody for defamation. It's pretty tough getting a letter, and it's even tougher having to defend a case. I'm going to turn it over to Andrew Rule, who had a pretty bad case just recently, to talk about his experiences.
Thank you. Just in opening, I'd recall that there was the great investigative journalist I.F. Stone in America many years ago, and he once said when he was a boy, he was a cadet reporter in a little hometown place in middle America, and he went to a house fire. He was only 17, 16, and he said, "God has sent me this house fire. This is marvellous. It's a great story to write." And it was only later, when he became older and wiser, that he realised that that fire was a tragedy, a life-changing event for the people affected by it. And I think most of us are a bit like that. As young journalists, we have that self-centeredness of the adolescent, and as we get older and wiser and sadder, and we endure love and loss of our own, we realise the effect that we can have on other people's lives. And I try to filter anything I do through that filter of what effect this would have if it were written about me or my family. Despite that fact, I have been sued or threatened with lawsuits at least 6 times in the last 20 years, and most of those actions have come in the last 10 or 12 years. It's my belief that you do become a target. As well as working in newspapers, I've published many books, some of which sold well, and that became a matter of notoriety in and outside our profession and the legal profession. And I think you do not get sued unless someone out there perceives that you are worth suing. And a fellow I know who was an injury lawyer, not a defamation lawyer, he's now a judge, and he said to me once, the first thing you do in our business is turn up and have a look at the heads around the table and work out who's worth suing, and then away you go. Who's worth it? Who's got the money? think that principle applies, and there's no doubt in my mind that there are some lawyers in Melbourne and especially in Sydney who trawl publications, and sometimes old publications, Michael, and they go right back to, something in 2007 or whatever that's been reissued online, and then they have a shot. And sometimes we get letters sent to us that are basically form letters that we've seen before, sent by the same lawyer about a totally different person. And why that would be, I think, is because they just prospect the papers, they prospect the books, they go through them line by line and work out where they can get away with it. Very quick example, I was called up to Sydney once to settle a case, a drunken former policeman who'd been disgraced in a Royal Commission. We made the mistake of repeating what was written about him by the Royal Commissioner. That is that he bashed somebody and kicked them while they were down. This man was living in, a flat in King's Cross. He's a drunk. He was a no-good ex-rogue copper. Some lawyer got hold of him and pointed to these words that had been repeated in our book from a Royal Commission and said, let's sue. We ended up settling with them. And when we did the settling, the lawyers insisted on getting just over 30 grand. They started at 50, we started at 5, and we met at 34. And do you want to know why that would be? Because their costs were 30 grand. So poor old ex-copper, the drunk, he gets $4,000 and his lawyers got 30. And that's what that was about. That was just a confected case run up to raise money for those who were doing the running. In another case in Sydney, we were sued. $25,000 was damages was awarded to the plaintiff, and costs of $290,000 were awarded against us. So you can see how crushing this sort of thing is. If it wasn't for those sort of things, I wouldn't have a mortgage. I think we'll leave the Madam Blake Mercedes for another time, although I'm happy to answer questions about it because I have got some thoughts about that particular case.
Thanks, Andrew. Matt Collins has run and defended and attacked on a number of occasions in defamation law and has even written a textbook.
Thanks, Michael. Yes, I've acted on both sides of the fence, Fairfax and News. I do mostly act for defendants, but like all barristers, I do occasionally cross the bar table and act for plaintiffs, but increasingly I act for defendants. And one of the things that strikes me is just how profoundly it affects a journalist's sense of worth and is a distraction from their day job to be embroiled in defamation litigation, which in this country has become complicated, time-consuming, distracting and emotional on both sides. Journalists rightly feel their integrity is being undermined to its core when they're sued for defamation. Allegations of malice are thrown about in almost every defamation case. I don't believe we have a core of journalists in this country who write maliciously. So I feel very much for clients of mine like Andrew, like Michael, who find their integrity at issue in defamation proceedings. More prosaically though, I've become increasingly concerned with how Australian defamation laws have fallen out of kilter with developments in the countries we most like to compare ourselves with. And by that I mean the United States, the United Kingdom, Canada, the other Anglo-Saxon democracies, New Zealand, Ireland. I think there are two reasons for it. We are unique of Western democracies in not having a Bill of Rights. We have no national statement of our fundamental values as a society, as a result of which it's all too easy for politicians and judges in cases to chip away at freedom of speech. Secondly, and perhaps at a more pedestrian level, for historical reasons, our defamation laws are laws of the states and territories and common law. To change the law requires a change of law in each of Australia's 6 states and 2 territories. We managed to achieve uniformity in our laws in 2005, a major achievement. It had only taken, well, Michael Kirby had written a report setting out the roadmap in 1979. It only took 26 years from then to achieve uniformity, but it's now impossible to change that law. at a practical level, even though we all know it's embedded with drafting problems, inconsistencies, and can lead to absurd results. The example Michael gives is one. Introducing a single publication rule should be a no-brainer, but it's a practical impossibility because it would require the agreement of 6 states and 2 territories. I think at a very high level there are 2 fundamental problems with Australian defamation law. The first relates to the way in which, over time, it has come to be a de facto cause of action for people who feel they've been offended and insulted by what journalists write. I use those words very deliberately. They're the first 2 words in the famous Section 18C formulation. Defamation law is supposed to be about damage to reputation, not about hurt feelings. Too often in this country, hurt feelings, to my mind, have become the core of the plaintiff's grievance. It's a matter which has been overcome in other jurisdictions like the United States, like the United Kingdom. Secondly, there are important developments in this country and elsewhere designed to protect responsible investigative journalism. But in this country, they have been stillborn. The High Court in 1992 found an implied freedom to talk about constitutional and government and political matters. Our legislation contains protection for reasonable discussion of matters in the public interest. But those defences have not once succeeded in this country. What that means is that responsible journalism has been interpreted as requiring a counsel of perfection by our journalists, a standard which is just impossible to meet, particularly for reasons such as those that Michael outlined in his piece in the Fairfax papers last week, in cases involving serious investigative journalism, matters of public interest, people in high office who would rather not have their misdemeanours splashed over the pages of the newspapers, and journalistic sources. So if I were reforming the law, I'd start with those 2 matters.
Thanks, Matt. I'll go to Gina next. Also has acted on both sides. Does defamation law in Australia need to be changed?
I'm not so sure. I think the 2005 uniform legislation brought about some really important reforms which for the most part favoured, if you like, the media or the free speech side of the scales. A cap on damages was introduced, and corporations no longer can sue for defamation, and that's been a major reform from the perspective of the media. There were, from the Victorian perspective, new defences introduced, for instance, contextual truth, defences that were known in New South Wales but not here. And from the New South Wales perspective, importantly, if you wanted to prove justification, you no longer had to also establish that what you said was in the public benefit. And so these were major important reforms, and they did tip the balance. Today, it is very difficult for a plaintiff. Matt said one of the major problems is that the defences that we have in the Act and at common law require journalists who don't get their facts right but want to bring themselves within a privilege to be able to prove to the court what he described as a counsel of perfection. That's true perhaps because courts judge what the journalist does through standards that might be stricter than perhaps those that are applied when writing stories. But it's only those cases that end up in court that get those standards applied to them. And for my part, I've acted for many plaintiffs in the pre-publication, for many defendants in the pre-publication stage, and I've seen really hard-hitting investigative journalism which is published and which nobody sues over because the work's been done. If the facts aren't right, at least there's enough of a proper basis to be publishing what you do publish. And it's important in society, particularly if you're a member of the mass media and you have such incredible power to affect the reputations of others, that care is taken about what you publish. I do think investigative journalism is possible in this country, but you just have to make sure that in publishing you try to apply those objective standards that the court will use when it comes to judge your conduct should, let's all hope, you don't end up in court at the end of the day. I'm sure there are reforms that we could all talk about, but for the major part, I think the balance at the moment is probably right.
Thanks, Gina. Finally, Tim Wilson, MP, former Free Speech Commissioner, now member for Goldstein, interested in your views about the law and the prospect of any change.
Thanks, Michael, and thanks everybody for the opportunity to be here. I sort of feel like saying everything Matt said, that reflects my opinion, so I'll avoid the need to repeat it. But what I will say, in addition to that, is the context and the environment we operate in around trying to get defamation law reform, I think, is somewhere between zero and non-existent. Principally for the political reason that Matt outlined around the capacity to be able to get different states and territories together, as well as the Commonwealth, to agree on a pathway of reform, in which I see no appetite at the moment. But the other substantial reason is because free speech as an idea and as a principle of a foundation of society actually doesn't live as much in the heart of our democracy as we'd like to think it does. I think we've seen that consistently, and while people talk and wax lyrical about the idea, and the one area where perhaps Matt and I might have a disagreement in terms of bills of rights, is that the whole idea of rights is a relatively foreign concept to Australians, apart from rhetorical flourish when necessary. It doesn't reflect our national character at all. The idea that we have a country built out of a concept of rights, it might in the legal system, but not in terms of most people's attitudes towards issues, and hence why things like whether it's reforming 18C or whether it's defamation law never gets to the broad-based purchase by the Australian public that we'd like to do so. But then there's also an absence of political will, because when it comes down to it, most people are completely hypocritical on free speech, and that includes the political class. Of people who look very narrowly at things that they think may affect them, or let's face it, in the case of defamation law, they may want to use to limit or to seek recourse against people who have said things. And we saw that no less than, and I said this at the time, so I'm not breaking any news, the case that Joe Hockey took against Fairfax a few years ago, which I thought was completely unjustified, despite, I think, Fairfax embellishing somewhat in the way it conducted itself. Defamation was not the resolution to the problem, simple facts and evidence was, and the capacity to be able to repeat that amongst a competitive media environment. So I think the prospects are relatively dim for wanting to achieve the type of reform that some people want to seek. But it does sit within a much broader culture where people do look at law as a recourse for problems in society, and for recourse for issues that they have a problem with. And that's a much bigger cultural problem that I think we're going to have to address if we don't want to see more laws designed to achieve the sort of objectives and the silencing that defamation can, particularly because we're not just talking about the punitive measures, we're also talking about the process and how simply the threat of action, as you've just experienced, can amount to people making a decision not to publish or produce certain content. And that is a completely disproportionate penalty because of the time, the energy and the cost involved, or distraction from your professional career, mindful that you do have to be respectful in the way you conduct yourself for what is often just the broadcast of a simple proposition.
Thanks, Tim. I guess my position is I don't think we should abolish defamation law. I think actually defamation law is a very, it's a curb on the excesses that Gina's referred to. It's just where the balance is between free speech and defamation law, and it seems to me that the free speech side of the argument doesn't get much of a look in, and the defamation law is a very technical kind of it's a series of cascading technical hurdles that you need to get over, and ultimately, in climbing over them, free speech really doesn't really get much of a look in. Matt was talking about that before, and you're saying that a Bill of Rights is almost preconditioned to having that kind of understanding of free speech, but I think most of us would probably agree that people have tried and failed on the Bill of Rights many times. Do you think it's a necessary precondition?
Well, if you look at all of the countries we like to compare ourselves with, it has in fact been the principal impetus for law reform. So in the United States, it's the First Amendment, which was the principal impetus for the New York Times and Sullivan reforms in 1964. If you look in the United Kingdom, the Reynolds line of cases, which freed up investigative journalism, was a direct result of Britain having adopted the European Convention on Human Rights and its protection for free speech. In Canada, the decision is called Grant and Torstar, builds on the Canadian Charter of Rights and Freedoms. The problem in Australia, for those of us who want to go in and argue for reforms, corresponding reforms here, is we don't have the ammunition to do so. We don't have a First Amendment. We don't have a European Convention. We don't have a Canadian Charter.
And yet, certainly, technical amendments of the kind you're talking about, a serious harm threshold, sorting out the electronic publication rule, surely are within the orbit of even the 6 states, are they not? Tim?
Well, we have within the orbit of the states the capacity to do things like establish legislative bills or charters of rights, which can shape the direction of law if they have control over it in isolation. But of course, they also reflect what's going on in comparable jurisdictions. But one of the things about bills of rights or charters of rights is that the most impact they'll ever have is at the foundation of a nation. If they're not there at that time, the system of law that develops around them takes a very long period of time. I always refer to it as like a garden, and bills of rights are like stakes for which laws will then grow around, and you'll have principles for which the garden will always have to grow around in order for it to be successful. And we obviously don't have that federally. We have a legislative charter in Victoria, but any significant shift, and I've been followed the Victorian Charter to a great extent, hasn't had a real impact in terms of defamation.
Gina, have you ever heard the Victorian Charter?
Look, I think at the moment you can say what you want, and you've just got to make sure that what you say is true. And if you don't get your facts right, and if you're publishing them to the world at large, then you at least have to make sure you've done everything appropriate to say what you're saying in a way that does not convey that you're saying something as a matter of fact. And I don't think you need charters or bills of rights in this country. I mean, the law is very clear. It's in its application that there are difficulties. The problem that you identified, that of a publication of yours that was uploaded onto the internet many years ago, now being downloaded and being republished to someone is a real problem that I think our courts are tackling with at the moment. There have been a number of recent decisions about the liability, for instance, of internet service providers and your own liability in relation to those publications. I think once those issues are ironed out, they won't cause massive problems going forward, because you can always tell with internet publications exactly how many people have clicked on and read that publication. And in the circumstances you're talking about, it's unlikely to be many people. So I think that we have the law that can provide the answers. And at the moment, there are a lot of cases because these things are going through the courts at the moment. But I think we'll see the end of that phase of the reinterpretation of the publication laws.
Just a couple of things there. Andrew alluded to the costs, and often it's not the threat of damages that is the real issue here, it's the costs. And, you know, I took the time to ask the General Counsel of Fairfax how much we spent each year on defamation. It was $4.6 million this year is the budget. Now, famously, the Age's entire editorial budget next year will be $100 million. That's virtually 5% of our entire budget goes on defamation law. That seems to me, Andrew, you know, and you take it personally as a book writer, as the biggest issue.
I saw an accountant yesterday, and he said, "How much do you still owe to those people in Sydney?" And it's, you know, 60 grand, paying off a debt of nearly 300,000. And this has happened. It's not the only time. So yeah, it's a massive thing, and over very little. It was over very little. This is to an elderly man with no assets, no real reputation, not running a business that can be hurt, over one word repeated from something that was written 15 years ago. Work that out. 300,000 in costs. Where's the proportionality? Gina?
Yes, look, I think costs are an issue, particularly with internet publications. And I've often wondered about whether the big service providers could come together and maybe establish some sort of court of arbitration of the internet, where those who want to post things online would be bound by the rulings, a quick, efficient ruling in relation to internet publications. But when you're dealing with a publication by the mass media, I mean, I think the costs are equally high for the plaintiff, and usually it's the plaintiff who can least afford it. There are obvious exceptions to that rule, but that's the way it goes, and our courts are expensive places to litigate. Unfortunately, you usually want to be in the Supreme Court because you want a judge-directed list with a judge who really knows what they're doing, which is meant to keep the costs down, but often doesn't. Although others might argue that even if you litigated these kinds of proceedings in a magistrate's court, the cost can still be the same. It might not make any difference to the cost at all.
And sometimes the judge does know what he or she is doing, and the appeal courts overturn it.
Well, that's right. We can all lose on appeal, Andrew.
We've touched a couple of times on the question of electronic publication. The other, apart from the sort of repeated publication of things on the internet, is that the law, as written in 2005, really doesn't contemplate the internet or social media at all. So it's not clear in the law who is the publisher if I put something on Facebook, for example, or if something is republished that I've written in Google. Do they have any liability? It's just not certain. Matt, is that a problem?
These are problems that courts have grappled with since the advent of the internet. I mean, in fact, the first internet defamation case in the world happened in Western Australia in 1994, two academics slagging each other off on a bulletin board. But it's true that our courts have been particularly slow to resolve questions which have long been resolved elsewhere. And again, I would argue that's because they don't have the benefit of simple, clear legislation. In the United Kingdom, England reformed its defamation laws with effect from the start of 2014, with a whole lot of really quite visionary reforms aimed at ensuring that people who are aggrieved by having been defamed online should go after those who wrote the material, not after those who have reposted it or liked it or linked to it through a search engine and so on. That's really quite a revolutionary reform, but it requires statutory intervention. Courts will never nudge the law in that direction.
In fact, now it seems that the courts are increasingly finding self-represented litigants arguing over things posted on Facebook and so on, which is a problem for the courts.
It's a big problem because, expensive though it can be to have a lawyer, things are much less efficient when you're dealing with unrepresented litigants who are given every indulgence by courts to ensure that they get a fair hearing. I would always much rather be opposed to Gina than opposed to an unrepresented litigant, ferocious though she is.
Okay, I'm going to open it up to the floor now. We've got plenty of time for questions. James Campbell is first cab off the rank.
Thank you. Michael, you actually touched upon what I was getting at, which is in relation to costs, the process is the punishment. It is, as you say, in theory, more plaintiffs can run things very cheaply. In reality, we can't. Every matter I've been involved in, even when we've been in a good position, we just can't afford to run the risk of going to trial. So when Gina says that the balance, the courts, the way you're treating these things is fair enough, well, who knows, because we never get there. Because in the reality of the pockets that we've got, it's just not possible. This brings me on to the point I want to make about a question I want to ask about, which is in relation to the hockey case recently. I mean, in my line of work, which is politics, defamation went out of fashion with politicians because juries, on the whole, tend to dislike politicians even more than they dislike newspapers. What hockey has done is open a quick, cheap and, from my view, entirely dangerous line of attack for politicians that they can now get their matters heard in front of a judge. Where there's no, you know, defamation going back to the Seven Bishops case of 1687 is something, in my opinion, that should always be heard by a jury. And I was wondering if I could get some comments on that from the panel.
I acted in the hockey case for Fairfax, so I'm scarred and biased by the experience. But I would say about that case that the substantive journalism prevailed. The long-form articles in each of the 3 Fairfax mastheads were found not to be defamatory. Where Fairfax lost was on a tweet and a poster, the posters you see outside newsagents.
Which apparently was worth $300,000.
200,000.
200,000. Beg your pardon. Shouldn't exaggerate that.
But there is a trend at the moment, you're quite right, James, there's a trend at the moment for plaintiffs, particularly in Sydney, to commence their proceedings in the federal court rather than in the Supreme Court system, because the federal court doesn't have juries. And there can only be one reason for bringing a defamation case in the federal court. It's not the natural place for the hearing of these actions. It's to avoid a jury.
And a judge is more sympathetic, Matt?
Oh, that's not been my experience. I thought the judge in the hockey case gave the matter a very fair hearing. I think he was driven to the results he came to by the way in which the law applied to a tweet and to a newspaper poster.
Can I just say, I was recently a plaintiff. It is ridiculous to say it's cheap for plaintiffs. The combined costs in my case will total $1 million. My damages claim, which we don't know yet, let's say I get 200,000. Who would take $1.20 with $1 million? It's scandalous. The power of the press, and what you need to do if you want to cut down on damages is apologise earlier, correct earlier, and admit you're wrong. The article that defamed me was factually inaccurate. The Age knew it and never acknowledged it. It wasn't just the imputations. It was Damien Shields. It wasn't just the imputations. The journalist made up facts, and plenty of them, and it was a circumstance where the Age never acknowledged it at any stage in the entire curial process. So you get what you deserve, and you should say you're wrong, and it would increase your standing in the community. No one thinks for a moment newspapers in 1,000 articles a day get everything right. But your attitude is, once someone calls you out, you just tell us all to piss off.
Is there a question attached to that?
Yeah, there is. It's too hard for plaintiffs. The risks you've got to take financially are just insane, and the damages don't go anywhere near the risk you're taking with costs.
Okay.
It's way too hard. I used to get 15 briefs interstate every year. Once that article went up, I got none. It's serious when you defame people and the whole world reads it. And that's exactly the attitude that everyone expects from the press.
Sorry, can I get you to identify yourself?
He said he was. It's Damien Shields. He sued Pat Bartley.
Yeah.
Defamed previously in front of everybody here by saying Pat Bartley. Not my experience with Mr. Bartley at all.
Okay.
I think it's disgraceful.
No, let's not have a slagging match between members of the audience. You two can discuss it later. I'd like to ask the panel if there's any comments on
It
this.
wasn't challenged that he made it up by his lawyers. They never challenged it.
Mr. Shields,
once.
thank you. Any comments?
Mine's a more a generic one about the capacity to seek reform and the role of the press, which is the dialogues I've had with the press, regardless of the side they're on in a particular case, is there's always been a relatively low appetite, frankly, for defamation law reform, except in the context of the individual journalist who might feel aggrieved because of a particular circumstance or situation. And to go back to the point that James raised before you'd raised before, Michael, about 4.6 million, which is basically 5% of the budget, it's kind of factored in and accepted that that's part of the cost of journalism, but equally the uncertainty of what might come out of a political process means that people would rather stick with the status quo. And if you can't get the press to come to some sort of common position to drive reform, what chance has it got?
Could I add an observation as well? I think what Damien says about culture is there's a real point underlying it. This country does not have a robust culture of correcting and apologising of the kind you see, for example, in the American media. Pick up the New York Times, page 4 is full of the corrections. We were wrong. We don't have that culture in Australia. But why is that? Part of the reason is because the correction and the apology can subsequently be held against the media as an admission that they got something wrong and in support of a claim. So in a funny sort of way, it's the immunity from suit in the United States that has encouraged cultural change there, I would argue. And it's very difficult to drive that cultural change in Australia in circumstances where the law is, as I would see it, unbalanced.
I'm not so sure about that, because I think under our new Act, if you apologise for the purpose under the offer of amends process, which was introduced and, as I understand it, has resolved a lot of matters before issue, but the apology cannot be held against you and in subsequent proceedings. And in my experience acting for plaintiffs, it's that real upset that a plaintiff feels. Firstly, if they've never been mentioned in the media before, to even be the centre of attention. And secondly, if they're a person with a reputation, a professional one or whatever it be, it's incredibly distressful to be at the end of a defamatory story. And an apology can take the sting out of everything. An apology can make everything go away. We all know that just from our own personal dealings day to day with people. If someone says sorry to you, you can get on with your life. And so I think apologies early on are a really good idea, and it might prevent a very costly trial down the track.
It's certainly true that, I think as journalists we're much more likely to issue corrections to the facts than apologies, which is an admission of some kind of feeling bad about things.
Yes.
Maybe that's not the right approach for us to take, but that is kind of the approach. Would you agree, Andrew?
Yes, I do.
In fact, you see an apology, you know that somebody's launched action and that somebody's agreed to do that.
I see we have experts can't even agree on this, but just as in the human at the human level, I believe we in the media should be more prepared to apologise early, because I think, as Jenna says, it does take some of the sting away, and yet we are reluctant to for the very reasons that Matt points out. So we're sort of caught between a rock and a hard place legally.
Matt, do you agree that the amends provisions are...
Yeah, so surprisingly they have worked. When I first looked at them, this is a process whereby when a person who's aggrieved by something in the paper raises a complaint with a defendant, be it media or otherwise, the media can offer to settle at an early stage. The provisions are incredibly complicated. They are riddled with drafting errors. When I first looked at it, I thought this will never work. The reality is people are crying out for quick ways of resolving these disputes, and they've been surprisingly effective. They're not effective, though, in serious defamation cases, serious cases where there really is a free speech concern that the media needs to defend on the one hand and a seriously defamatory imputation on the other.
Thanks. Sorry, yep.
Just in relation to online publications, and you've obviously got, we're talking a lot about cases against the media, but how do you see sort of the current environment working in relation to individuals or not-for-profits or people who actually really do rely on social media and the internet for their business, which is where everybody works and lives now online, and in terms of the traditional sort of defences and processes that they face, particularly when you've got a range of people potentially involved in publication?
For my part, I think it's incredibly difficult. The sea change with the internet, of course, is it is a global medium of publication in the hands of every single citizen, and it's permanent. So we are seeing Facebook, competing Facebook profile cases flourishing everywhere, because understandably, people are aggrieved by something which is up on the internet forever, unless you can reach a resolution. But all of the complexities that are inherent in a defamation case involving the mainstream media apply with equal force in online disputes. And yet you're dealing often with people who are less resourced, less able to access good quality advice, and often litigating their cases in courts where judges don't have any expertise in the area.
Yes, and I think as a matter of policy, I know what's happened in the United States and in the United Kingdom, where the internet service providers are less on the hook than they are in this country. I think as a matter of policy, it's important that they remain on the hook, because they're the parties that control what is available to be downloaded from the internet. And they're the only parties that can bring about a quick resolution. And it's, after all, what the plaintiff usually wants in a defamation action today is to clean up their reputation, their electronic reputation, which is on the internet and which is there forever. We used to say that today's newspaper is tomorrow's fish and chip wrapping, and that's just not so anymore. The Google search engine means that that's just not so. So I think if we could have quick resolutions that involve the internet service provider, that can get the material off the internet quickly, can maybe have a quick correction or statement published, not even necessarily an apology, everyone can move on and avoid expensive litigation. If only we could come up with some procedures to achieve that in this country.
That's I think what's known as the right to forget in Europe, isn't it? Which we don't have a right to forget here. But I wonder if defamation law is the right way to address that.
Can I say I fundamentally disagree with what Gina said for this reason. Internet service providers and so on, and search engines like Google, are in no position to assess the weight of free speech underlying something which has been posted by a third party on Facebook. The default position, if you render internet service providers and search engines liable for things written by others, is they will pull it down rather than face the risk of suit. That is the very definition of a chilling effect on freedom of speech.
Can I just echo my sentiments? I completely agree with Matt. But in the end, for a credible media, particularly media company, I think to maintain a sense of public confidence and licence in the community today, they do actually need those mechanisms to actually alter and change content. It's not going to change the perpetuity of some nature of content, because it's copied, it's pasted, it's replicated, reappears, whether it's on Wikipedia pages or anywhere else, on perhaps, shall we say, less credible content sites. But you do need a process of resolution. I think that's what is actually going to help companies build their credibility in, frankly, an age when you talk about what's happening in the media landscape, is there's a clear demarcation between those sources that are going to seek or have and would wish to seek to maintain their credibility against the huge volume of other content which people, perhaps not as discerningly as they should be giving perhaps a little less weight.
I totally agree with that. And I think for journalists, the Defamation Act and the laws are the tools of trade. They should be seen that way, because it will set the traditional media apart from every other person out there in society who today is a publisher, who can publish to the world at large from their computer in their living room. And we need a respected traditional media which is set apart from the rest.
And paying $5 million a year to do so. Which is the ticket. That's the ticket that needs to be clicked. Is that right?
You also get the masthead and the generate the content and the revenues as a consequence of that as well.
And there's no reason why journalists can't be doing that job for themselves. You don't necessarily need to involve lawyers. That's why I said make it the tools of your trade.
Yeah, but the law is so complex and so expensive if you step wrong that
if you step wrong, the fundamentals are pretty. I think the fundamentals are pretty clear.
Okay.
For how to write a good story that's litigation proof.
I'd invite you. You're quite welcome to come and try sometime. Johan?
Johan Lidberg, Monash University. First a comment and then a question. So there is something fundamentally wrong with the balance in Australia when you look internationally for a media company to have a $5 million budget to deal with defamation per year. In an international comparative perspective, Gina, that's just not, there's something wrong there. So there's a comment. A question, Tim, to you. If there is something so clearly strange with the amended law that surely couldn't have been the intention from the amendment in 2005 that we would have a 1-year limit, and then that doesn't apply. And I hope, Gina, you're right, that the courts will sort this out. Meantime, it may take years. If your government brought that to a COAG meeting and said, listen, this is not really working. Would there be a lot of disagreement, you think, in changing that simple thing?
The short answer is I have no idea. And you would hope there wouldn't be because, as we've already discussed, the biggest problem with the current law, as with many laws, it's not just this law, is keeping up with the rate and pace of change of technology, and that you need to give proper licence and direction of statutory framework to allow the courts to operate. Do I think if it went to COAG it would create a problem? I think probably on the balance of probability, no, but anything that goes through COAG doesn't go through easily, simply or quickly, and so it could sit there for a long period of time. So I'll take the point up with the Attorney General. I suspect what would ordinarily happen is once people say, we're going to amend defamation law reform on this very basis, it would then say, well, why aren't we actually looking at the full spectrum of issues that affects defo law and technology, and then it would end up in a long process which could take years. So in terms of priorities, frankly, until, and Matt alluded to this before, and others have alluded to it in their comments, until you get a really bad case of something, it normally doesn't prompt any reaction or response because it's not seen as a political imperative, and let's face it, that's what happened with the ADNC discussion, where you had a particular case which people took umbrage at, and we've had a series of other ones that have followed since then, and the same is basically going to occur. That's part of the reason why I wasn't silent on the Fairfax hockey case, because my hope is that that might actually lead to a discussion, but unfortunately we've kind of been misfiring.
Thank you. We've got a question up the back there.
Yeah, I'm Nathan from Kilvington. Now, as a student, say I was to write an article about, others, what advice would you give me?
Where would you be publishing it, Nathan?
Oh, well, I know, say the local, the newsletter, there we go.
The school newsletter?
Or anywhere, really.
Right, well, yes, write it very carefully, and I think use that filter that I referred to. Would this outrage me if it were written about me or my family, or my cousin or something? That's the first test, is would this be fair if it were done about us? That's the first test. The second test, of course, is to go to one of your friendly lawyers on the school council, preferably ones that don't charge.
The problem with the offence test, though, isn't it, Andrew, that some people, like bad guys, people who are doing the wrong thing, deserve to have that called out and to feel offended.
I'm assuming that our Kilvington student is not writing about such people, but yeah, of course. And to be offended, it shouldn't be. I've been offended many times by what people have said and written. In fact, a couple of times it was a QC in one case. And I, in fact, spoke to the very wise man David Polton about this once, where I thought I'd been borderline defamed. He said, forget about it. You don't want to know, do not go down this path. And it was great advice because in the end I got over it and we didn't have to worry about the whole thing. I probably had been defamed. I certainly had been defamed as much as some of the people that sue us. But his advice was, leave it alone, it'll go away, you'll feel better next week. And I did.
Can I just raise a point that Gina actually raised before, particularly around perceptions of proportionality and justice based on whether you're writing about somebody who's a public figure or not. And one of the realities is if people don't have any public profile, having anything written about them that they don't control can very quickly lead them to take disproportionate reaction to recourse if they're unhappy with it. So just be careful about who you're writing about, because that will normally determine whether they're prepared to take action. Also, if they've got deep pockets and they can afford. And this is, I think, one of the great challenges for our age, is there's so much content out there and so much content available. And so if you're writing about a public figure, frankly, very quickly defamation law, as far as I'm concerned, is purposeless, because anybody can write anything about anybody on an electronic platform, and there'll be enough content there to counterbalance that in response. So the best thing, if you want to protect yourself, if somebody's writing about you, if you're on the other end, is to make sure there's plenty of content out there on the internet about you already.
Thank you. My name is Jason Boslin from Melbourne Law School. I've got 2 points and 1 question. The first relates to just something that hasn't been touched on yet today, and that is the relationship between pleadings and the operation of defences, which really stifle the way in which defences operate and the way in which they're really make them unsuccessful, if you like, and make them very technical. So I think in terms of being, I'm not a journalist, but speaking to journalists, one of the difficulties is working out in advance before publication as to whether or not a defence will apply. It's almost impossible if it all depends on how the plaintiff pleads their case. So that's a fundamental problem, I think, with the way in which the law operates, both in the courts but also in practice, in terms of being a chilling effect. The other is, I think we need an Australian Law Reform Commission inquiry into this. We've had multiple inquiries into privacy, but nothing in relation to defamation for many years. I can't remember when the last one was. Matt might remember, but
1979.
1979. So I think the time is right for an Australian Law Reform Commission inquiry. The last is a question, and that's just about reform. So I've sort of get the sense that there's not much appetite for reform. It's sort of seen as being a bit impossible, something that can't really be done. I'm not so convinced. I wonder whether or not at a federal level we need to look more at whether or not action can be taken, in particular in relation to multiple publication. It's multi-state, I think constitutionally it would be possible. And I think there needs to be a greater look at that. And I just want to get the panel's opinion on federal reform.
Can I deal with the legal question and let Tim deal with the political one? Legally, you're quite right. Our constitution would enable the federal parliament to pass a defamation law that came very close to covering the field. The corporations power will pick up all media entities. The interstate commerce power will pick up all publications crossing state borders. So the electronic media, the print media, anything on the internet, telecommunications could all be covered. In fact, Philip Ruddock proposed doing that to overcome the ban on corporations being able to sue back in 2004, but was persuaded not to do so. So legally, that's absolutely right.
I thought Philip Ruddock actually basically uses the basis for threat as a basis to get the states to harmonise their laws. And I'm not saying it's impossible, but I just don't think there's any political will or impetus. In fact, in the discussions earlier about reforming the RDA in this term of government, one of the senators, Dean Smith, made the proposition that rather than focusing just on the RDA, we can get bogged down into details about the line of law about racism. It really needs to sit amongst a broader package, and I've made that recommendation myself, and defamation law would have to be a part of that. Not in isolation, but they'd obviously be the two big ones. That so far hasn't come to pass. And the ALRC inquiry would absolutely have to be one of the key ingredients for that, a dispassionate assessment. And I think we can actually have a reasonable degree of confidence in the ALRC's processes to deliver sensible recommendations, at least because in their broader review out of traditional rights and freedoms, which was commissioned by the Attorney General in the last Parliament, actually came up with some discussion around exactly these issues, particularly in federal law, and I thought landed, while not giving clear and specific recommendations about a way forward, recognising and identifying the tension, which could then be led to say, well, firstly, what's being done in other jurisdictions, and obviously the technology, that's an important part of that, but also assessing against the common law framework, and in the absence or the vacuum of some sort of Bill of Rights, how would you go about doing that to make sure that it achieves the objective? So, in broad proposition, I think you're right. It's when and somebody sees the basis to do it, and that's why I keep making the point about cases. It's often cases that lead to prompts of action to then see further change.
So what you're saying is that as journalists seeking reform, we should pray for a really, really bad case to hang it on, and for the feds to come in and take over.
What you need to do is find the cutest little kitten that ever, or no, kittens can't sue, but the cutest little child who's never done anything wrong and decide to throw all things at them, and then you'll prompt the backlash in return. I'm not suggesting you do that, by the way.
I should add, sorry, that the Ontario Law Reform Commission is actually undertaking an inquiry into defamation at the moment, so that's, it's still, even in countries where they do have a charter, there's still something which is on the legislative.
It seems to me that what I'm hearing in the room is that the big complaint is the cost of the proceeding and the cost for the media, and that's a reform that might not be specific to the media law. That's a reform that might be about the courts and the way that these proceedings are conducted. So I think we have to be careful to make sure that's not the problem. There's some other broader reform that we need to address.
Yeah, in fact, costs seem to be similar for media defendants as well as ordinary people on social media. We could go on all day, but we are out of time. Thank you very much, everybody, for your questions. Thank you to the panel, Gina, Matt, Andrew and Tim. It's been a great discussion and plenty of food for thought. Thank you very much for coming.